The clerk will report the title of the bill.
Senate 3960, an act to amend Title 35 United States Code to provide a good faith exception to the imposition of fines for false assertions and certifications and for other purposes.
Pursuant to the rule, the gentleman from California, Mr. Issa, and the gentleman from Georgia, Mr. Johnson, each will control 20 minutes. The chair recognizes the gentleman from California.
Madam Speaker, I ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and insert extraneous materials on Senate Bill 3960.
Without objection.
I yield myself such time as I may consume.
The gentleman is recognized.
Madam Speaker, this bill is a win for small businesses and the small inventors. Small businesses may qualify for reduced application fees when applying to the United States Patent and Trademark Office. However, under 35 USC Section 41 and 123, a small business may claim small entity or microentity status. For example, a standard cost of filing a utility patent is $320. A small entity, however, pays just half that, $128. And a microentity is charged only $64. When Congress passed the Unleashing American Innovation Act of 2023, the law required the United States Patent and Trademark Office director to impose punitive fines on entities falsely asserting or certifying entitlements to these reduced fees. This was intended to deter unscrupulous actors from claiming the benefit for which they did not qualify. However, in that bill, we granted no exceptions under existing laws for those who made an honest error in good faith. For example, if an employee is mistakenly categorized as a contractor rather than an employee, a good faith mistake could cause them to claim the wrong status. Or if, by mistake, information provided by another company to a licensee could also result in that. The impact of these punitive fines would be disproportionate to the honest mistake. These harsh fines may deter entities from seeking the benefit of small or micro entity status, since the potential cost of the fine would far outweigh the benefit. To ensure the small business benefit from can get those reduced fees, in concert with the House, Senate 3960 gives the PTO director the authority to waive punitive penalties when a business demonstrates it acted in good faith. I urge my colleagues to support Senate 3960 and ensure that small businesses, if claiming incorrectly, have an opportunity to make right their mistake. And I reserve the balance of my time.
The gentleman reserves, and the gentleman from Georgia is recognized. The gentleman from Georgia is recognized.
Madam Speaker, I yield to myself such time as I may consume.
The gentleman is recognized.
Thank you. I rise in strong support of Senate Bill 3960. This legislation makes a minor technical change to give the Patent and Trademark Office the flexibility to decide when to penalize patent applicants for false certifications of eligibility for fee reductions. When Congress passed the Unleashing American Inventors Act as part of the government funding package for fiscal year 2023, we did so with the intention of making patents no longer the sport of kings, but an opportunity for inventors to make a decent living. Innovators should not have to work for a big tech company, major manufacturer, or any other powerhouse of industry to be able to file a patent. But that is exactly what often happens. Financial hurdles associated with obtaining and owning a patent, from hiring a lawyer to searching for prior art to paying standard application fees, can prevent individuals from seeking patents for their inventions. Barriers to entry like these hurt everyone, but above all, they hurt women, veterans, and minorities who often do not have the resources to go it alone. The result is that fewer ideas make it out there into the American innovation space. All of our talent becomes siloed in just a few companies, in just a few industries, and prospective creators shelve their ideas for another day. The Unleashing American Innovators Act sought to disrupt the current state of play by making a series of good government changes to the way the PTO works, including by increasing the discount on fees for small and micro entities and by imposing penalties for making fraudulent certifications to obtain a discount. But I'm sure many out there will be shocked to learn Congress sometimes makes mistakes. And in creating these new fee waivers and associated penalties for trying to abuse said waivers, we neglected to consider the applicants too that can make honest mistakes in their applications. If innovators are too afraid to apply for financial exemptions because penalties for honest mistakes can lose them a chance at a patent, then all of our improvements may as well simply not exist. Senate Bill 3960 would correct this minor error. Under this legislative fix, a USPTO director would no longer be forced to find a good faith actor that erroneously asserts that they are entitled to a fee reduction for small or micro entity status. By allowing for honest mistakes in the application process, this technical fix will ensure that everyone has a seat at the table. I want to thank the chairman of the Intellectual Property Subcommittee, Mr. Issa, for introducing the House version of this legislation, which I was proud to join, along with Congresswoman Ross. And I want to thank Ms. Ross for leading the Unleashing American Innovators Act. This legislation has already passed the Senate, and I encourage all members to support it so that we can send it to the President's desk. And with that, I reserve the balance of my time.
The gentleman reserves. The gentleman from California is recognized.
Madam Speaker, I would ask if the gentleman from Georgia has any further speakers at this time.
I have no further speakers, and I'm prepared to close.
Madam Speaker, we're prepared to close.
The gentleman reserves, and the gentleman from Georgia is recognized.
Thank you, Madam Speaker. Failing to account for good faith mistakes harms the exact same people the Unleashing American Innovators Act sought to help. Individuals and entities that can barely afford filing fees certainly do not have the financial resources to weather a hefty fine. Moreover, unlike large entities, the prospect of losing a patent associated with an erroneous application could very well mean losing everything. Smaller entities, therefore, are the most likely to avoid the risk of applying for the very programs that exist to help them. This legislation will ensure that the USPTO director will no longer be forced to find inventors who make honest mistakes when they apply for a patent, ensuring that the people we were trying to help in creating the program are not chilled from participation. Again, I support this legislation. I encourage my colleagues to do the same, and I yield back the remainder of my time.
The gentleman yields. The gentleman from California is recognized.
Madam Speaker, in closing, we often get chastised in the House for not admitting our mistakes, but when a technical error could potentially lead to damages to the private sector, it's one of those areas I'm proud to say the Judiciary Committee is bipartisan and quick to recognize, and in concert with the Senate, we have done so here today. And so I urge all of my members to vote for it and yield back.